Welcome to another session of the Law in Action Explainer series. Today, we are diving straight into probate, wills, and family drama in Nigeria. We are going to bring some much-needed structure to a topic that is notoriously chaotic, deeply emotional, and honestly, absolutely fascinating. If you've ever wondered what legally happens to a person's life's work, their assets, and their businesses after they are gone, you are exactly in the right place. Let's get right to it. Okay, let's dive into this with a question that sounds super simple, but rarely ever is. When a Nigerian passes away, who gets the car keys? Just picture this for a second. You're at a typical Nigerian family meeting just days after a loved one has passed. Suddenly, everybody in the room is a legal expert. The uncle who hasn't visited in a decade confidently remembers he was promised the family house. The distant cousin insists the deceased treated him like a son. It gets loud, it gets passionate, and man, it gets confusing. But here's the reality check. While the family is busy debating, the bank manager, the land registry, and the investment companies, they are entirely unfazed by the noise. They are asking one cold, hard question. Where is the grant of probate or the letters of administration? Because in the eyes of the law, the loudest relative at the family meeting is definitely not the legal successor. So, why is there always so much chaos? Why isn't there a clear plan in place? Well, it mostly boils down to cultural deflection. You bring up the word will or estate planning, and you are almost guaranteed to hear this classic response. God forbid, though, I'm not dying anytime soon, right? There's this deep ingrained cultural belief that writing a will somehow invites premature death. But think about it. We don't buy car insurance because we plan to crash tomorrow, do we? Refusing to make a will doesn't prevent death. What it actually does is guarantee that the life you spent decades building, the businesses, the properties, the wealth, is just going to be subjected to bitter, drawn-out disputes. Estate planning really isn't preparation for death. It's absolutely essential protection for the living. And this brilliantly illustrates what happens when we skip that crucial planning. In Nigerian law, there are basically two main paths for administering an estate. If you die with a valid will, your chosen representatives apply for a grant of probate. The court essentially looks at it and says, yes, these are the exact people you chose. Let them carry out your wishes. But if you die without a will, which is a situation known legally as intestacy, you don't magically avoid the legal process. Instead, you are forcing your family to apply for letters of administration. The stark difference here, it's all about control. Under a will, you choose your representatives. Without a will, the law chooses them for you, following a strict statutory order of priority, like Section 49 of the Administration of Estates Law of Lagos State. It completely strips the power of choice away from your family. Now, we absolutely have to address the single biggest myth in Nigerian succession law, the next of kin. Honestly, people genuinely believe that if they put their siblings or child's name next to next of kin on a bank form, that person automatically becomes the undisputed owner of everything when they pass. Let me be aggressively clear about this. They absolutely do not. A next of kin is literally just an administrative emergency contact person. That's it. Being the next of kin does not make you the next owner. And hey, you don't have to take my word for it. The Nigerian legal system has repeatedly shut down this misconception. Take the landmark 2001 case of Chime versus Chime. The Court of Appeal unequivocally held that a next of kin is merely a contact person for emergencies. They acquire zero automatic rights to inherit the estate. The Supreme Court reinforced this exact same principle in Adaku Amadi versus Edward Nwosu. So, if a family member storms into a bank demanding access to accounts simply because their name is on that next of kin line, they are going to hit a massive brick wall. The law requires formal, officially authorized administrators, period.
To make the whole shebang even more complex, Nigeria doesn't just run on one set of rules. Depending on how you lived, who you married, and how you died, your estate could be governed by 3 completely different overlapping legal systems. It's like a giant puzzle. First, statutory law applies if you married under the Marriage Act or wrote a statutory will. Then, you've got customary law, which varies wildly by region, like the Yoruba methods of Idi Igi, which distributes assets by maternal line, or Ori Ojori, which is strict equal distribution. And finally, Islamic law, governed by the principles of Faraid. What does this actually mean? It means 2 neighboring families living on the exact same street could have entirely different inheritance outcomes, just based on which legal system gets a seat at their family meeting. But let's see how this evolved into the modern era. Because customary law isn't just some free pass for discrimination. The Nigerian courts have boldly stepped in to modernize inheritance and protect fundamental rights. In 1997, Mojeku versus Mojeku struck down the Oli Ekpe custom that essentially disinherited women. Fast forward to 2014, and the Supreme Court handed down 2 massive game-changing rulings. First, Ukeje versus Ukeje, which declared Igbo customs preventing female children from inheriting completely unconstitutional. And then Anekwe versus Neke, which aggressively protected widows from discriminatory practices. The message from the judiciary is crystal clear here. Tradition is deeply respected in Nigeria, for sure, but discrimination is absolutely not. The Mr. Ibu lesson. We actually saw the real-world impact of all this estate ambiguity recently in the highly publicized events surrounding the late beloved actor John Okafor, who we all know as Mr. Ibu. Following his passing, the public witnessed a really heartbreaking fallout. There were public allegations from his widow regarding financial difficulties, and then counter-allegations from a son from another relationship regarding the sale of properties. Now, as an explainer of the legal facts, we aren't here to take sides or determine who is right or wrong in that specific family dynamic. But the situation serves as a vital, impartial lesson in estate planning. When wealth, multiple properties, and a blended family structure collide without a clear, legally binding estate plan, well, the result is sheer chaos. Because here's the thing, without a will, the grieving process gets immediately sidelined by these critical super agent questions. Who actually controls the assets right now? Who has the legal authority to sign the papers to sell a property just to pay for basic expenses? Who can walk into the bank and unfreeze the account without letters of administration or a grant of probate? The answer is nobody. Thriving businesses just grind to a halt. Bank accounts are totally locked down. And that vacuum of official authorization is so quickly filled by public allegations, deep confusion, and unfortunately, fractured relationships. So the only reliable way to bypass this ambiguity is to create a legally valid will. But, and this is a massive but, under the law, like Section 9 of the Wills Act of 1837 or Section 4 of the Wills Law of Lagos State, your final instructions have to strictly follow statutory formalities. First, it must be in writing. Second, it must be signed by the testator. That's the person making the will. Third, and honestly, this is where so many people fail, it must be attested by at least 2 witnesses who are present at the exact same time.
The Supreme Court in Inebise versus Osha made it incredibly clear. If you fail to follow these exact steps, the entire will is void. It doesn't matter how obvious your intentions were. The probate registry doesn't care what your uncle said. They only care about strict legal compliance. Finally, order versus chaos. So the crucial point we're getting at is really perfectly captured in this exchange rate metaphor. A will can take a few hours to prepare, but a probate dispute that can consume several years to resolve. Sitting down with a lawyer to draft a will requires a brief moment of facing your own mortality. Yes, but procrastinating on that task means you are trading a few hours of mild discomfort today for years of legal fees, asset deterioration, and bitter family warfare tomorrow. It's just a terrible exchange rate for the legacy you've worked so incredibly hard to build. As we wrap up this explainer, I want to leave you with this profound thought from probate practitioners. A good will cannot stop grief, but it can prevent grief from turning into litigation. Ultimately, estate administration isn't really about legal technicalities or who gets the car keys. It's about clarity. It's about leaving your loved ones with peace instead of a massive puzzle scattered across 3 generations. So I'll leave you with this. What kind of legacy are you leaving behind? Is it one of order or one of chaos? Thank you so much for joining me for this explainer. Keep learning, keep planning, and I'll catch you next time.